Hello everyone and welcome to today's lecture. So today we are looking at the legal studies lecture with ATAR notes. So hopefully everybody is having an okay day, everyone is doing well. So let's get into a little bit of a welcome. So ATAR notes provides a bunch of free resources. So obviously you have accessed the lecture, but we also have a wide variety of other resources that you can access. So I just wanted to point those out. So for example, we have hundreds of downloadable study notes for you. If you feel like you're lacking in a certain topic that you want to revise a little bit more, you don't have the time to make notes, you don't really want to make notes, you can definitely have a look there. We also have lectures, so not only for legal studies, but I'm sure you're aware for most subjects. So if you are looking for a little bit of extra help or a little bit of revision, we do have a wide range of subjects where we provide these lectures for, including maths, English, sciences, etc. So please do take a look if that's something that interests you. We have discussions, so we have online Q&As for you to be able to ask all your burning questions and get responses. Videos, so I know that sometimes just the plain old boring notes can be a little bit annoying and you might want to change it up. So we have got engaging online revision for you to access as well. Newsletters to help you stay in the loop. ATAR calculator if you have a certain ATAR goal in mind, then I would definitely recommend to try and see, I guess, what sorts of marks you'd need to get a certain ATAR. Obviously there's not going to be 100% accuracy, but it's pretty close most of the time. So yeah, definitely have a look at that if you're interested. We've got articles with study tips and strategies for you to access as well. So if you feel like you're stuck or you have certain questions on how to study or what to do, or how to create a routine, we have a bunch of different articles for you to access, and we have heaps more things. So these are just some of the resources that we have. If you're interested in any of these resources, then I would highly recommend that you go onto this link here. So when you put in this link, you'll be able to access most of these after registering, or all of these, sorry, after registering. And more resources. So again, all of our resources are really beneficial, so I would highly recommend that you do have a look at them. These are some of our these are some of our paid resources. So we've got TuteSmart, which is online tutoring from elite recent Year 12 graduates. So again, this is something that is definitely very beneficial for lots of students who feel like they need a little bit of extra help in a certain subject, certain topics, certain areas. Would highly recommend this platform, which is TuteSmart. Study guides, so printed revision materials with top tips to help you get the best marks. So again, some of you may have already seen some of our study guides. They are the colourful books that are there for a wide range of subjects, and we've even got text guides for different texts in English, but they're like quite thin, and I think it's like a really nice condensed version of your textbooks, which can be very thick and very overwhelming sometimes. So having that summary or condensed version of the most important parts of each topic from the syllabus can be really, really helpful. I know, for example, in certain subjects they also have like different cases, different examples, evidence, things like that embedded into that as well. So that can be really, really useful for you to access if that's something that you feel like will benefit you. And Ed Unlimited, which is essentially all the study guides all in one place. So it's like a Netflix of all of the study guides that you could ever use or utilize. So that's the online version. But obviously you have the option of also buying a physical copy, so that's completely up to you. Again, the same website or link applies if you would like to access any of these resources or find out more information about any of these resources. Again, we've got the link down there. Alright, so Now moving on to the lecture. So today we will be going through the legal studies lecture. Just a little bit of an introduction. My name is Uzma and I will be taking this lecture today. So hopefully all of you can benefit, learn something new, and obviously this lecture is recorded, so you can definitely ask questions in the live Q&A chat that we've got for the lectures. So I'm going to get right into it. So a little bit of an introduction into today's lecture. We're mainly going to split it into two different sections, which is crime revision and how to smash trials and skills, etc. Like, obviously it doesn't only have to be trials, but I know trials is like that looming exam that you've got coming up. So again, this is really just a how to smash legal studies component anyway, so even if you don't have trials coming up, etc., any assessments, anything like that, I think it would still be of benefit. And we'll also have a look at the syllabus, because I believe that is probably one of the most important parts to be able to understand and pick apart in order to really excel in the subject. Is the first thing you look at is the syllabus. It's a really essential component to achieving success in really any subject. So yeah, so in terms of crime as well, today we'll be looking at the most important points of crime that will help you smash your trials, your HSC, your assessments, so that you can move into that band 6 range or region and beyond, and just be able to achieve success in this subject, which I know that is definitely achievable, but to be able to just push past that band 5 and into that band 6 is that line can be sometimes difficult to cross, because you just need to be doing that a little bit more. So hopefully some of these tips there will help you be able to make that jump. All right, so before that, I did want to touch on your syllabus. So just a little bit of a summary. I know most of you may already know this if you've been doing practice exams, but if not, I've put this slide in there because I think it is very, very helpful to just understand exactly where your marks are coming from and what's in your exam, what's assessed where, and in what form. Because legal studies is one of those subjects where it's not just all the topics mixed and you can get basically an essay on any topic or an essay on any or like a multiple choice on any of the topics. It's very, very much split in terms of the different marks, and they let you know which topic, right? So for other subjects like business studies, you're kind of in question in terms of which topic you don't really know, so you have to prepare for it all. But for legal studies, you have been given where or which topics will be assessed in which section or question style. So like most exams, we do have a multiple choice section, we have a short answer section, and we have an essay section, but we have 3 essays, which is not like many other exams, which may only have 1 or 2 essays. This one has the 3. So multiple choice will be 100% without a doubt on crime and human rights. So 15 of those marks, or 15 of those questions, because they're all 1 mark each, will be coming from crime, and 5 of those marks will be coming from human rights. Okay, so that makes up the bulk of your 20 marks. You don't really have a choice with that. Obviously, we all know what multiple choice is. Short answers, we then move on to short answers, which the syllabus section is human rights. So human rights is your area that you will be assessed on. This is going to be 15 marks. It's going to be split up into a couple of questions. And again, you just have to do those short answer questions. That's not a choice. Essay number 1. Remember, we have 3 essays. Number 1 is a crime essay. It's worth 15 marks. And again, you don't have a choice. That one's compulsory to do. So within crime, it can be really any topic. So you would need to make sure that you are preparing for that. So having your legislation, your cases, your media, being able to understand all of the different topics in enough detail to be able to write an essay for it. Essay option 1. this one is 25 marks. So in legal studies, you will go through 2 options in terms of your syllabus, so 2 different topics. So for example, when I was in school, I went through family, and so family law and world order. But obviously it's very much up to your teacher, your school, which topics or which options those are. So option number 1 is 25 marks. So you do get a choice with this one. So you're given 2 questions and you choose one of those questions and you answer it. And again, for the second one, 25 marks. And again, you choose one. So this exam is really, long exam. It's a lot of work. I feel like, 3 essays plus short answer plus multiple choice can be a little bit overwhelming, which is why sometimes students get a little bit stressed about it. But regardless, I think if you have enough practice, it should not be an issue. So, something that I did was I would always put in the work, put in the hours, put in that practice to make sure that I could do the best possible job to achieve the marks that I wanted to achieve. So yeah, that's basically a summary of where your 100 marks are coming from the legal studies exam. So all HSC courses have a syllabus that sets out what must be taught by your teacher and what can be examined by NESA, right? So you want to be able to make sure that you know exactly what you can be examined on, and your syllabus is literally a list of that. So using your syllabus as a list of, hey, I know this, I can tick this off, I can tick this off, actually I'm not sure about this, let me highlight it. That is exactly what you should be doing in order to understand what you know, what you don't know, so that you can separate the two and then achieve success in terms of, okay, now I can focus on what I feel like I need to improve on, and then essentially go from there. So therefore your syllabus is your checklist. It is something that you use to tick or cross what you know and what you don't know. Remember that you cannot be assessed on anything outside of your syllabus. So HSC courses specifically are very syllabus heavy, meaning that they set out every single dot point that you need to know specifically. So I did a couple of HSC courses, so business studies, economics, legal studies, and for all of them I made sure that I really emphasized understanding the syllabus and making sure that I used it as a list to understand what I knew and what I did not know. My syllabus was so important. Whenever I would have a study session, it would be the first thing on my table, right? So it's really important, and I would highly recommend that you also implement the syllabus into every study session that you have. So structuring your notes also in terms of the syllabus is something that I wanted to quickly touch on as well. So structure your notes to mirror the syllabus. So dot point information, kind of like in that structure. So staying on top of your notes is the best way to ensure that you don't fall behind in the HSC, right? So it's less stress, happy times, good marks. Really, they all are correlated and all go hand in hand to be able to achieve success in this subject, right? So for example, we've got legal representation and legal aid, which is one of the dot points, and then you just kind of put your summary dot points or your summary notes under that, and then you go into the next syllabus dot point, for example, burden and standard of proof. So then you have your summary notes. Okay, what are those things? Again, use of evidence including witnesses is a syllabus dot point. Under that, you've got just a summary of the notes of that, so that, for example, a couple of days before your exam, your assessment, whatever it is, you can just read over that and then have a high-level overview of every single syllabus dot point. And remember, you cannot be assessed on anything outside the syllabus, so you're basically covering 100% of the content that you could be assessed on your exam, your assessment, etc. Hopefully that's making sense, but I would highly recommend that you use this technique to be able to achieve basically 100% coverage and to be able to feel a higher level of confidence going into any exam or assessment, which I know I did because I utilized this method. Okay. So HSC prelim, I normally, whenever I do these lectures, I get a couple of questions in in terms of the difference. So I thought I would just kind of put in a little slide just to emphasize the difference, or you know, be able to explain the difference. So structurally, the HSC syllabus isn't overly different to the prelim syllabus. So if you are currently in prelim watching this lecture, that might be comforting to know if you are finding the prelim syllabus okay to go through. There is a greater expectation that you do refer to the syllabus in the HSC, because again, when you start going through HSC exams, you see every single question is from some part of the syllabus. So knowing the syllabus, really, I cannot emphasize enough how important it is to know it and to understand it and to memorize it and to make sure that you know every single dot point in terms of content for every single dot point that there is. HSC requires detailed and extensive understanding of each dot point, whereas that may not have been the case in prelim, because remember, there is no external exam in prelim for most students, right? Like HSC is like the main external exam. For some of you, trials can also be an external exam. You may have had external exams if your school had bought papers from outside, but really the HSC is like the main one that everybody has. So some of you may have had exams in prelim that do still refer to the third dot point here, which is the detailed and extensive understanding. But remember that HSC emphasizes it so much more. So make sure that you are aware of that in terms of, you know, going into year 12. HSC requires well-researched and accurate legislation, cases, and media. I can again not emphasize this point enough either. To be able to know and memorize and learn different legislation for different dot points, different cases for different dot points, and different media for different dot points was so integral to my success in this course, right? So I would highly, highly, highly recommend that you do the same. So something that I did was, for example, if I go back to the syllabus slide, for example, legal representation, legal aid, you see how I've got a case there? There's a case there. So I would literally put, you know, mark this up or highlight this so that it was evident that that was my case. I would always put my case in a way that it would separate from the content or the notes of the content. So for example, this is just an understanding of what this is, but then this is the actual case, which you can tell because it's in the box. So you can even highlight it a different color or make the font different or whatever it is, so that you can differentiate the case from the content. And then you can also do the same for legislation and media as well. So in that way, again, you've got that syllabus structure, so you know that you're getting 100% coverage, and then you've also got cases, legislation, media for every single dot point as well. So I think that's really important to make sure that you understand, and I would highly recommend using that method, because it definitely helped me you know, make my life a lot easier in terms of being able to integrate these into my notes, which I know I often also get a lot of questions surrounding how to, I guess, be able to memorize such that many legislation, that many cases, that many media, and people don't really know where to start from. So I would highly recommend going dot point by dot point and then being able to weave that in. Also, where do you get your legislation, cases, media from is something I often get asked, sorry. Again, go dot point by dot point. You can definitely have a look at your textbook, which is what I did. I would always read up on the textbook and see what the textbook was saying for that particular, I guess, topic. So for example, apologies. So for example, legal representation and legal aid, 100% I know that this case will be in the textbook because it's like the most popular case for this specific topic or dot point. But I would also then go and search up what I could potentially see online about it, especially for media, because I don't think media is as prominent in most legal studies textbooks. I think that's something that I would highly recommend that you just kind of search online and see what articles you can find. And also for legislation, I think textbook would be your go-to, but then you can also do additional research. But I would highly recommend additional research more so for cases if there's not a particular case that you are really understanding or that you can't find in a textbook is to do additional research online or through you know, other websites. Like you can have a look at Ostly, things like that, which I've also got a link in this presentation for, I believe. So yeah, for those two, look at the textbook. If you can't really see anything that you're understanding or there's not really much in the textbook, definitely have a look online, and I'm sure you can find many articles, cases, etc. Talking about different areas. Yeah, so that is sort of a well-rounded summary of, I guess, the main differences that I wanted to highlight. So yeah, a little bit of a in-depth also into legislation, cases, media. I wanted to dedicate a slide to this because I know I get questions on it again, just to emphasize that making sure that you have legislation, case law, media, and international instruments also apply. They may just not be as common, but I would still recommend that you have them in there. So yeah, you will definitely need these for your essays, and sometimes you may want to incorporate them into your short answer human rights answers, especially if they are more than 4 or 5 marks, then I would highly recommend. Or if they're 5 marks plus, then have the you can have like an example of a case, or like mentioning a legislation, or mentioning a media piece, but mainly the legislation, case law can be helpful. But for essays, you would probably need to integrate most of these, and by most of these I mean definitely the first 3, sometimes the 4th one. Depends on the question. Sometimes questions emphasize international instruments, sometimes they don't, so that's a little bit up in the air and up to you depending on your question and depending on your knowledge and your expertise in terms of how you would approach that. So having a well-researched and accurate example to support your writing is absolutely critical. So having those examples, having those cases, legislation, media can help support what point you're trying to make, because at the end of the day, you're making some point. For example, if your question's asking you to make a judgment, so that's just allowing you to back it up and just showing the marker that you know what you're talking about, you've done your research, and that you can, you know, continue on and explain how you're able to get your point across. So I think that's quite important and something that I wanted to quickly emphasize. All right, legislation. So your teacher will usually give you the relevant legislation. So normally I didn't really go and research more legislation. It's kind of just like the common ones that you will have. So your job isn't really to research legislation, but to just memorize it and remember it, which I know can be hard for some students, but just making sure that you put in the time and don't leave things to the last minute in this subject, because it's a lot of content and a lot of memorization, so you don't want to leave things to the last minute, because I guarantee you it will be very difficult on the day before your exam to memorize legislation, cases, media, etc., and content for all of those subjects, for all of those, dot points. That will be that will be a very tough ask for anybody, so please don't leave things to the last minute. However, if you feel like you want to do a little bit more research into legislation, I've got a couple of links there for you to access as well. Okay, case law. Again, you don't need to read the entire case law judgments. This is not expected of you. These are hundreds and hundreds of pages. If you plan on taking law in university, then you can definitely save it for then, but please don't read hundreds of pages. You don't need to be going into that level of detail. All you need to really know are the basic facts and the issues and the decision. Those are the 3 main things. So what are the facts of the case? What's the issues that have arisen? And then what was the decision, right? What was the verdict, for example? Case law should be used to illustrate legislation being applied or highlight the effectiveness or ineffectiveness of the law or in the law. So, for example, you have a certain piece of legislation, you have a case where the judge will apply that piece of legislation, and then you go, actually, that was a really effective case because we were able to achieve a balance between victims, offenders, and society, for example. Or that was actually a very ineffective case because our moral and ethical standards as a society were not really met. Right, so that's an example. And again, you may be wondering where those terms are coming from. They're all coming from the syllabus. The best place to access case law, again, I've put in the link there. I was just mentioning it a little bit earlier, but OSLI is a really great place to sort of access different cases. Again, when you click on the cases, it will be hundreds of pages of notes. You don't need to read all of that. Just get the main 3 things, which is the facts, issues, and a decision. Media. So media can comprise of anything from a newspaper article to a podcast to a documentary to an online opinion piece. The main one that I used is the newspaper articles. So you could say the Sydney Morning Herald, and then you could like quote the title of the piece or a specific quote from the article. But again, all of those apply. I also had a few online opinion pieces on different topics or dot points where there was controversy surrounding ineffectiveness or effectiveness of the law, because that will help me answer the question of effectiveness, ineffectiveness, right? So media is typically used to demonstrate your awareness of a current affairs, but also to add a scholarly argument or point of view. You're basically showing the marker, hey, look, I'm not just waffling, I know what I'm talking about, I've done my research, and yeah, I can go into detail and in depth in terms of my understanding of this specific dot point or issue or topic, especially if you're making a judgment, right? If you're arguing that actually the law is only partially effective and there are areas of ineffectiveness, then you could say, and this is shown through this opinion piece or this article. So how to find media? There are a couple of ways that you can do this. First of all, watch the news, right? SBS, ABC, whatever you want to watch, just turn on the news and have a look. Read the newspaper, right? Make sure that you just have any form of access to the news. I know reading the newspaper sounds like ancient, but really, you can even, I guess, subscribe to an online newspaper if you want to, but really, just having any access to any form of news. My favorite was to just download a news app so that I could just subscribe to some of the news like forums, or like, I don't know what you call them, like news companies, I guess, like Sydney Morning Herald, ABC, SBS. The Conversation is a really good one for opinion pieces, is to just subscribe to them, and then if you have a certain topic, then you can also look there, or you can just every day just scroll for like 5 minutes and have a look at what's trending or what's making the news and seeing if that relates to anything that could possibly help you in your essays or that you could include in your notes. This is really good also for subjects like economics, where you also need to keep up with the news, so it can be something that you can implement for other subjects as well. And to listen to podcasts such as A Law Report, Please Explain. I know ABC also has a couple of podcasts where they're educational. So yeah, if you're into podcasts, that can also be a way to get your daily dose of news. But yeah, essentially just making sure that you are aware of what's happening currently within the law, what changes are being made, if there's any reforms being made, and then if you're doing subjects like world order or human rights, obviously human rights everyone's doing, but if you're doing the option of world order, just keeping up to date with the news that's going on around the world as well in terms of the law, the UN, etc. All right, others. So international instruments should also be used in essays. So these include things like treaties, conventions, declarations, covenants. These are typically made at the UN level. So you can definitely have a look and just search those up. They shouldn't be too difficult to find regardless. Statistical data as well is always a good one to have up your sleeve, but it's not essential really. So you don't have to, but if you want to take that extra step to go above and beyond, you can definitely have a look and see if you could integrate some stats, but you also have to memorize them, so try and make sure that they're not too complex so that you can remember them. Also keep an eye out, as I was saying earlier, on law reforms. So Law Reform Commission reports, which will normally highlight where the law reform is coming from, what it means, etc., and royal commissions into issues that are affecting the community in Australia. So you could have royal commissions into a wide range of things, but normally it's like issues that impact the community. So for example, I believe we had one with the banks and their lending practices. I think we also had one in relation to our aged care system, which is quite flawed. So a lot of the systems that majority of people believe are flawed and that need to be looked into and examined in a deeper way and audited almost. Basically there will be a royal commission into that, and those are always really, really interesting and provide great insights into different areas of the law, especially ineffectiveness of the law, which I really wanted to emphasize. Ineffectiveness. Effectiveness is normally something you will be asked at some point in your exam, so making sure that you're aware of that and that you can talk about that to a sufficient level, I think, is quite important. All right. Now moving on to the nature of crime, which is, I've just sort of got a snip of the syllabus. Where we've got the different dot points literally going through, okay, this is exactly what I need to know. So I need to know what the meaning of crime is. I need to know the elements of crime. So what is actus reus? What is mens rea? What are strict liability offences? What is causation? So being able to, and then for example, categories of crime, you've literally got a list of every single category. So this is so helpful when you are practicing, when you are studying, to go, yeah, actually, I know what the meaning of crime is. Like, literally, you could go, yeah, meaning of crime, I'm set. Elements of crime, all good. Actually, I'm not really sure about some of these categories of crime. I'm not really sure about what public order offences are or what preliminary offences are. Let me do a little bit more research into that. Let me try and see if I can find an article about that or a case about that. Things like that can be really, really helpful. So just have your syllabus next to you whenever you're studying any part of any topic, because it's going to be from a part of the syllabus. Then you basically have like practice questions that you could use, and they range from describe, which is one of the like lower term verbs, so it doesn't take that much effort to answer. Describe would probably be a 3 or 4 marker. You don't normally, so you for example describe the nature of crime, so you just go and do that. So cause of crime, effect of crime, etc. So it would be kind of similar to explain. Recognize the different categories of crime, define summary and indictable offences. So this would probably be in your notes regardless. Examine, investigate. These are more of the higher term verbs, which will be more of like your essay style. Now moving on to elements of crime. So what are the elements of crime? Well, we've got actus reus, mens rea, and then we'll also have a look at causation as well. So actus reus, what does it mean? It means the guilty act, basically. What does that mean? It means a physical act or omission. Act, we know what that means. It's the action of doing something that is wrong. So if you go and steal, I don't know, if you go and steal a computer from Harvey Norman or whatever, I don't know, then that is a physical action that is the guilty act. So if somebody can prove that you went and stole that computer, that's enough. That's the act, that's enough, then you're found guilty. Omission is your lack of action. So, for example, if you're babysitting and you see that the child that you're babysitting is choking and you just sit there and you ignore it, and then that baby ends up going to hospital, whatever it is, then that's the lack of action. You saw that the baby was choking, you didn't do anything. That's a lack of action, so that's an omission that is also essentially a guilty act. So, common examples are also like the punch. So if you punch someone and, they pass away, which has happened before, which is why we now have stricter one-punch laws, stabbings, things like that, those are all guilty acts. Right, so mens rea, we then move into mens rea, which is the guilty mind. Now the act, once you're caught on camera punching someone and then you see them get knocked out, that's it, you're found guilty. It's very easy to prove, right? Mens rea is not easy to prove because it's the guilty mind. You have to prove that that person had the intention of committing that crime. So, this is the criminal mindset. So this can be intention, it can be recklessness, so just lack of care, basically, or criminal negligence, right? So again, negligence, just you're not really paying attention, don't really care. But again, this is harder to prove because there's no act that you can sort of support that mens rea or guilty mind with. It's just the guilty mind. And then we have causation, which is where the prosecution, the people bringing the action to the court, must show that the accused's actions caused the harm. So that there is a causal link, there is a link between the action of the accused and the harm that occurred. So if the accused punched someone and the harm was that that person passed away, that is causation. There's a clear link between the punch, which is the action, and the result of that, which is a person passing away. So relationship between cause and the effect. So hopefully that's making sense, but that's just a high-level summary of what that is. Again, there's not really that much more to it, just being able to understand the three, and just being able to understand the difference between actus reus and mens rea. This normally comes up in multiple choice. Most of the first section does, so yeah, shouldn't be too difficult, hopefully, so far. All right, less serious crimes. So these are related, so basically strict liability offences are less serious crimes. They're not really going to be things like murder or anything like that. So these are less serious crimes. They're related to, or they're restricted to minor offences. So there's no mens rea required to be demonstrated. You just basically have to do the act and that's enough. Actus reus, basically. You're caught in the act of stealing. You're caught in the act of speeding. Mainly my favorite example to give for strict liability offences is speeding because it's just so easy to understand. Basically, if you're speeding and a police officer catches you, they pull you over and they give you a fine or they give you a ticket or whatever it is, they give you a fine or they take away a few points off your license, then you're caught in the act. The police officer doesn't have to prove that you have the intention to speed. They just have to prove that you were speeding, and then they can do that through, for example, if there was a camera or if they have like a certain system in place where they can check your speed, then that's essentially enough. So for example, traffic offences, speeding, not wearing a seatbelt, littering, selling alcohol to minors, those are all examples. So in some cases, there can be a defence to strict liability offences by appearing in court and proving the act was an honest and reasonable mistake. Okay? So if you go into court to, I guess, go and talk to the person and say, hey, actually, I wasn't speeding or actually had a reason for not wearing a seatbelt, whatever. That's how you can fight it, but most of the time you just, it's a minor offense, you just sort of take it on the chin, right? So most people won't really go to court for it, but if you have a reason, you can do that, you can fight it, the system allows you to do so. What's the advantage? It's easy to enforce, so you can treat people equally, right? However, the main penalty is a fine. So for example, on-the-spot fines, things like that, and that can raise issues about effectiveness if you have the same amount of fines. Like, let's say the fine for speeding is, you get a fine for $200. You can have someone that is, really struggling with money or really struggling financially, and that $200 could be the reason that their family eats that week or doesn't. And you could have somebody that $200 is like $2 for them. It's like nothing. And they're both getting the same fine. It's really only deterring or harming one of them, which is obviously the one that's struggling financially. For the other person, they're probably not going to care as much, which is why I think, obviously, then you've got the demerit points as well, which is probably going to deter the person that is doing financially well as well. So there's something to keep in mind in terms of just being able to understand or to gain a deeper insight into what these mean. Okay, so categories of crime. So offences against the person, sovereign, economic offences, drug offences, driving offences, public order offences, and prelim crimes are all different types of offences, or categories of crime rather, that we see. So let's go through each one. So offences against a person, this is the intent to cause harm or injury, right? So most of this will be covered in the legislation that I'm sure all of you know of if you've gone through any element or any part of crime before, is the Crimes Act 1900 NSW. This is the most important legislation for crime. Please, please, please know it. So the examples of this, again, it's like quite self-explanatory. Things like homicide, murder, infanticide are all examples of offences against that specific person. Offences against the sovereign, so these include political offences. So these could be, obviously, so they're obviously going to be against Australia or the Prime Minister, whatever it is. And the safety of the public is essentially compromised. So treason, sedition are examples of that, and it has a maximum penalty or sentence, of 25 years imprisonment. So again, I feel like most of these are pretty self-explanatory. Just make sure that you know a couple of examples of them and you actually know the categories of crime, which is, all of these listed here. Again, these are normally asked in your multiple choice section. Don't really see it come up in many of in really crime essays, but yeah, just make sure that you know it, just in case. But regardless, I don't think most of the first section doesn't really come up in the essay. It's normally the latter sections that do. Economic offences, so these involve people losing money or property. So crimes against property could be things like larceny, robbery, break and enter, obvious examples of crimes against property. White collar crimes, so things like embezzlement, tax evasion, so avoiding taxes, not paying taxes, insider trading, so gaining benefit by having internal or information or private information be released, or not released but shared amongst a group of people so that they can benefit before it goes out to the public. Computer offences, so cyber stalking, virus hacking, are all examples of computer offences. I'm sure that most of these are pretty obvious to all of you. Drug offences, so there are a couple of things to keep in mind. This is really important when you think about drug offences, is it can be either one or multiple of these. So use, possession, cultivating, selling, or importing. If you're caught doing any of these, you will fall under the category of having committed a drug offence, right? So any of these or multiple of them. And remember, they have to be banned drugs, because even technically Panadol is a drug as well, so that's obviously a legal drug, but banned drugs, right? So main legislation is NSW is the Drug Misuse and Trafficking Act. And so small quantities can be passed into summary offences, which are small offences or minor offences. The way that I remember the difference between summary and indictable offences was to think summary. So when you write a summary, you're shortening something, you're making it smaller. So it's a smaller offence. Indictable, larger offence, which is just the other one. So where do we access that? Summary Offences Act 1988, New South Wales. So so it basically ranges from 9 months to 2 years imprisonment in terms of driving offences, which is the next one. This is obviously a strict liability offence. We talked about that earlier, so you don't need to prove your intention to speed. You just have to prove that you're speeding or that you didn't have the intention to wear a seatbelt. You just need to prove that you weren't wearing a seatbelt, right? So that is cause for 2 years imprisonment, normally max. If you are under 18, you sort of go to a local court, not the children's court, even though you are a child, because of the type of offence. So that's something you can keep in mind when you are studying driving offences. Then we have public order offences, which are basically acts that are inappropriate or offensive, and the public peace is disturbed. That's the way I remembered it, public peace disturbed. So things like riots or affrays are basically examples of that. Preliminary offences or crimes, these are offences that occur prior to the crime being committed. So the example that I always give to students is before you go to HSC or you start your HSC, you have to go through prelim. Preliminary essentially means before the act, right? So before your HSC, you go through prelim to prep for your HSC. In the same way, before the crime, you go through everything to prep for the crime. So those are prelim offences. So everything prior to the crime being committed. So for example, attempts, you must establish intention, which is really difficult, right? Compared to, for example, strict liability offence where you're just caught speeding. Conspiracy, which is where 2 or more people plot, plan to commit the crime. Again, quite difficult to prove because you need to prove that they had planned it, they had intention, blah, blah, blah. So it can be a lot more difficult to prove preliminary crimes compared to just the actual crime, which just requires actus reus. Okay. Hopefully that's making sense so far. So again, just a bit of a summary of indictable summary. I went through a little bit of it earlier, but essentially summary offences are less severe. So they're minor offences, like for example, graffiti or littering. You're not going to go to jail for those, but they are still offences and they will still be, considered or classed as committing a crime. So all summary offences are heard in the local court. You can appeal to district or Supreme Court if you wish, and your appeal may get denied, it may get approved, just depends on whether they believe you have enough of a case there. Indictable offences, so these are serious offences or major offences like murder or homicide. So these go through a committal proceeding for indictable offences, so in the local court to determine prima facie, which is basically is there enough evidence for this case to continue or to even go forward, because if there's no evidence then there's no point. How will anybody be able to determine a verdict or a decision? Sorry, so indictable offences can be heard in the district or the Supreme Court. This just depends on the offence and the scenario that's playing out. You can obviously appeal, but again, it's subject to approval, right? So it's not that immediately you can go and appeal and it will be accepted. It has to go through a process of approval. So summary offences are heard by a magistrate, which is the judge for the local court. You don't call a local court person, or I guess you don't call them a local court judge, you just use the word magistrate, which is exclusive to the local court. Indictable offences will be heard by a judge. The difference though is that in summary offences, which are smaller or minor offences, there's no jury, whereas in indictable offences there is a jury. Judgment. So the judgment and punishment will be passed on by the magistrate, because again, there's no jury. And if you have, if you are aware of how the decision-making system works, then you would know that for indictable offences, the judgment is made by the jury and the punishment is made by the judge. So the verdict of guilty, not guilty will be determined by the jury. If the jury decide that there is a guilty verdict, the judge will decide the sentencing or the punishment, what that person will face. That person will face, sorry. So punishment, so for summary or minor offences, it's normally something like a good behaviour bond or a fine, 2 years imprisonment normally, or up to 5 years if there's more than one summary offence. So if you've committed multiple, then it may be the case. Indictable offences, these are normally hefty fines or imprisonment. For example, I've got some of the different examples of how long, normally around 25 years. So that's, obviously a lot more extensive, a lot bigger than the ones that are there for minor. Sorry, in terms of legislation, we have the Summary Offences Act, which I did discuss earlier, and then for indictable, we just again look at the Crimes Act 1900, New South Wales. Okay, so moving on to the different parties to a crime. So let's go through these. So principal in the first degree, principal in the second degree, and then we have accessory before and after. So principal in the first degree, this is the actual perpetrator. So this is the person who punched the person and then the other person passed away. Or this is the person who committed the murder. So they will receive the higher sentence because they're the one who've committed the crime. They're the principal offender or the actual perpetrator. Then we have principal in the second degree. So this is a person present and assisting the principal in the first degree. So, for example, this is a person who restrained the victim so that the principal in the first degree could stab them. Right, just an example of that, but again, could be anyone that's in the second degree is just helping the person in the first degree. Accessory before the fact isn't at the crime scene, but aided and abetted to the principal in the first or second degree to commit the crime. So this is before the fact. So, for example, they researched when the victim would be in a particular location, so that the first two can go and commit the crime. After the fact, person knows about the crime and helped the offender afterwards. So somebody who drove the getaway car would be the after the fact. So again, these are pretty self-explanatory. It's just being able to retain this information. But normally I think even the names sort of, or the titles of each one make those concepts quite self-explanatory. Hopefully it's all making sense. I think making sure that you have examples that you can refer to for these will aid you significantly in terms of remembering each one as well. And crime prevention. So we have situational and social crime prevention. So situational crime prevention is making it more difficult to commit crimes by increasing the risk of being caught. So basically creating situations where crime is just very unlikely to happen. So if you lock your windows, it's less likely that someone will be able to climb in and steal or rob you. Blue lights in the bathroom, which are normally there to make it difficult, I believe, to inject drugs into you, because it's like the color is makes it difficult. Sniffer dogs. So sniffer dogs, obviously, I normally will see them with the police or at the airport, the places like that where they're able to sniff out drugs or things like that. So again, makes it more difficult to commit a crime. So if a person is thinking of taking illegal drugs to another country, they may think twice if they're aware that there will be sniffer dogs that will make it more difficult for them. So it creates a situation to prevent crime. CCTV, obviously, It makes it more difficult, for example, for someone to steal something, and lockout laws as well. So what's the main issue here? It just moves people to a different place to commit the crime. So if somebody sees that there's CCTV in a certain shop, but then they go to another shop and there's not, they'll just commit the crime there. Or if they see that there's blue lights in a certain bathroom, they may just go to another bathroom where there's not blue lights. So although it's creating a situation where it's preventing crime, it may just take the crime elsewhere. Therefore, we need to really dig deeper, right? We can't just stop there and create situations, because we can't create a situation of crime prevention every single place. Not every single place is going to have blue lights in the bathroom, for example. So we need to, I guess, look deeper into where this issue is coming from, or the root of this issue of why do people actually even commit these crimes? And then we can sort of fix the issue from there. So that's where we look at social crime prevention. So this is where we reduce the social factors that are likely to cause a person to commit a crime or to target potential offenders. So this may occur due to poor parenting, low-income family, where they feel like, okay, in order to eat today, I'm going to need to steal something, right? Or uneducated, where they're not able to then go out and find a job as easily, because most jobs may require some experience or education. Early contact with the police, association to criminals or criminal behavior, where you fall into that cycle of criminal behavior and it's very hard to come out of that cycle. And so there's a lot of cases that I've read where a lot of these factors have applied to people who have committed crimes. So that's really important to note. So we want to try and reduce these factors so that these people don't fall into this cycle that's very difficult to get out of. So what can we do? Intervention programs, workshops, try and encourage youth to come into these workshops, or encourage them to take on education so that they avoid going through different routes which may lead to criminal behavior. So for example, we've got a Youth on Track program which targets 10 to 14-year-olds with low literacy, neglect and substance abuse, so that they are able to sort of not lead themselves to a life of crime, but rather be able to redirect them towards a more appropriate way of just living and being able to avoid those problems and prevent crime, essentially. What is the issue with this? The ineffectiveness in this area is that it's not cheap. It's really expensive to run these programs. You need to hire people. You need to basically be able to hire people, to have enough people available to be able to run these programs, and that's expensive. So somebody is going to be bearing that cost. Normally it's the government who is setting up these programs, so they need to be able to schedule or to have a set budget dedicated to that. So that can be an issue at hand for social crime prevention. All right, now I've got a couple of practice questions for you all to have a look at. So I will just leave the question up for a minute, and then you can just have a look and see which option applies. So these ones might be fairly easy or not, but hopefully after the lecture, after we've gone through these concepts, they are looking a little bit easier. So again, have a look and see what you think the answer is, and then we will go through the answer. Alright, so which term refers to a person's intention to commit a crime? Is it A, mens rea, B, actus reus, C, doli incapax, or D, ratio decidendi? The answer for this one is going to be mens rea. Okay, it's the intention to commit the crime. They have the guilty mind. Okay, so that one was fairly simple. All right, so we've got some information. So Jordan and Terry make a plan to burn down an abandoned building. The next night, Terry goes to the building and sets it on fire. Jordan and Terry are both making the plan. Terry is the person who commits the crime. Into which category of crime does Terry's actions fall under? Is it A, B, C, or D? Again, have a think about it, and then we'll go through the answer. So again, with this one, I don't think the answer would have been that difficult. It should just be property, right? They're going to abandon building, they're setting it on fire. That is very clearly offences against property. Now, what is Jordan's involvement in the situation? Remember, Jordan and Terry make the plan. Terry goes and burns the building. So what is Jordan's involvement in the situation? Is he the principal offender? Has he not committed a crime? Is he accessory after the fact? Or has he committed a preliminary crime? Which one would be the answer? Okay, so the answer is going to be the preliminary crime. Why? Because he helped Jordan make the plan. Sorry, he helped Terry make the plan. Terry then committed the crime. Okay? So he has committed a crime. It's not the actual crime, so he's not the principal offender. That would be Terry. He has committed a crime, so it can't be B. He's not an accessory after the fact because he wasn't there after the crime was committed. He was there before the crime was committed. So, and another option could have been he's an accessory before the fact, which would have been correct. But instead of that, we've got preliminary crime, which is also fine. All right, we're now going to move on to human rights. So, nature and development of human rights. So, human rights are the basic entitlements that everyone possesses, simply by being human. So, human rights have 4 characteristics, which we would be aware of. They are universal, which means that they are the same for everybody, regardless of your age, your gender, your religion, etc. Like, none of those things matter. They apply to every single person. Inherent. They are a birthright of all human beings. Every single person has access to these rights. They cannot be given up or they cannot be sold, which is they are inalienable. You cannot alienate anybody from these rights, and they're indivisible, which means all rights are equally important. So the government does not give you these rights as you already have them. It is the responsibility of the state to recognize them. Okay, so again, they're inherent. You know, it's not that the government goes, okay, from today you have these rights. No, as soon as you are born, you have access to these rights. The government does not, so we went through that. The human rights basically evolve over time depending on community values, you know, what are the ethical standards, what are the moral standards, what applies, what doesn't, changes over time, so that will change with that. So, the abolition of slavery. So what is slavery? Slavery refers to a person being completely under the control of another person and being considered their legal property. So they're not given the basic human rights that we talked about in terms of these concepts really apply to them. So there has been a significant push for reform regarding this issue, and as a consequence, most countries abolished slavery from 1833 to 1865. Because people were like, well, what's this? It doesn't make sense, right? So this is something that we talked about here, where we said, well, the community values and ethics changed. So Australia was slow to respond as they only abolished slavery in 1980. So in response to slavery, international formal statements were developed, such as the UDHR 1948, which is also referred to as the Universal Declaration of Human Rights, which is a international document. It is not something that is Australia specific. It's sort of something, it's like an international document that is basically a formal statement. It's something that is recommended, or it's a guideline for people to follow, but essentially states have their own their own decision to make as to whether they would like to implement that into their into their own system of laws, or not. Making it a soft law, so not really enforceable, whereas the hard law is enforceable. So in Australia, anything embedded within legislation is a hard law. Soft law would be things like the UDHR, which are simply guidelines for lawmakers, etc. So we have the International Covenant on Civil and Political Rights, which is our hard law, which is from 1966, enforced in 1976. So the ICCPR, the International Covenant of Civil and Political Rights, is a hard law and it's legally enforceable. So that's the difference between international documents. They're not enforceable. Every state has its own sovereignty. They decide which laws apply, which laws don't. So normally a lot of these, like Universal Declaration, blah, 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 they're not really going to hold much value unless the state themselves decide to implement that into their local system of laws. So Australia became a signatory to the treaty and enacted domestic criminal laws to deter and punish slavery. So the main law in Australia is to prosecute individuals who use slavery for forced labor or sex slavery, is the Commonwealth Criminal Code 1995, where slavery was inserted in 1999 under Section 270. I know this is so many words and like it may seem like a little bit overwhelming, but just remember, basically this is just a summary of how we came to abolish slavery. So think of it kind of like a story in terms of what was the context, what does it result in terms of the law and changes in the law, and how does it impact Australia specifically. So first successful prosecution for this concept was in the R.V. Tang case of 2008, where she received 10 years imprisonment on 5 counts of sex slavery after trafficking prostitutes from Thailand. So clearly we can see effectiveness of legislation because of this case. So this is again something that I wanted to emphasize that I was talking about earlier on in this lecture. How can you use cases to back up your points? This is an example of doing that. So for example, if you had a question talking about effectiveness of abolition of slavery or effectiveness of laws in terms of slavery, this could be a case that you can implement. So further amendments to this law were seen, for example, in Slavery-Related Conditions and People Trafficking Act, where it takes into account all forms of servitude, for example, even including forced marriage. Alright, then moving on to trade unionism and labour rights. So trade unions refer to the collective group of workers formed to protect the rights of workers from particular industries or occupations. So initially it was illegal to be a part of a trade unions. Oh, how times have changed, right? So now we have trade unions for almost every single industry, I believe. So yeah, so first it was, when it was initially founded as a concept, it was illegal, and so thus employees had really little to no rights. Employers sort of just told them what they would be given, and employees sort of just had to deal with that. So trade unions emerged during the 1850s and during the Industrial Revolution, which, if you studied that in history, was a really, really horrible time for employees and for people who went out to work, because they were put into horrendous conditions. A lot of child labor was being utilized. There were very low wages, there was no safety, and there were long hours. So it was really just not a great time to be an employee. That's where it sort of the concept came from. And so to protect union rights internationally, trade unions' rights are contained within the UDHR, which is the Universal Declaration of Human Rights, which we touched on earlier as well. So, however, we have because again, it's a soft law, we have another legislation that has been implemented into Australia, which is the International Covenant on Economic, Social and Cultural Rights of 1966, enforced in 1976, and was implemented and introduced basically human rights such as the right to form and join trade unions. So the first prosecution regarding this law in Australia was seen actually in the case of R.V. Trivedi, 2011, where he was sentenced to 250 hours of community service and fined $1,000 for abusing an employee from India. So again, very obvious and very clear examples of effectiveness of the law. Some people may argue ineffectiveness and say actually that's not enough of a punishment. So regardless, you can sort of choose either side and argue your case. However, this small penalty lacks the lack of deterrence. Obviously, some people will be like, oh, I don't mind doing that. So it may not really stop people, right? Yeah, so today trade union membership has declined due to the increased use of enterprise agreements in a bid to increase productivity. So nowadays we don't really have a set pay or a set, I guess, amount of working conditions or whatever it is, like a set structure. It sort of varies from employee to employee or grade level to grade level. So awards, for example, are not as common as they used to be. Yeah. Universal suffrage. So this is basically the right of all people to vote as a part of democracy. You may think, okay, when was this not a case? Well, obviously we know women were not allowed to vote. We also know Aboriginal people and Indigenous people were not allowed to vote until quite recently as well. So initially voting was limited to wealthy men, and then it extended to all men in 1983, and then federally to all women in 1902, where South Australia was the first state to grant the right to vote in 1894. Some Indigenous people were not granted the right to vote until 1962, with WA and NT granting it in 1967. So internationally, the right to vote is contained within the UDHR as well, 1948. However, again, we know that this is a soft law, which is a huge area of ineffectiveness in the system. We have these great declarations, but they really don't have much value until they are enacted into legislation of the relevant country because, again, state sovereignty. International Covenant on Civil and Political Rights 1966 was enforced in 1976 and was implemented and introduced basically human rights such as the right to participate in public affairs, saying that, okay, you are somebody that's living in this country, you're impacted by the decisions made by the government, so you have the right to choose who you vote into government. In Australia, the right to vote is recognised as an express right within our constitution, so that's going to be very difficult to change. Taking something out of the constitution is very, very difficult because if you remember anything from prior studies, you may remember something called a referendum, which needs to be held in order to change that. However, issues regarding the right to vote arose in the case of RV Electoral Commission, where prisoners sentenced to more than 3 years imprisonment in Australia cannot vote. Next up, universal education. So universal education is the right to basic education, specifically primary education, so from kindy to year 6, regardless of who you are. So push for universal education didn't really begin until the 19th century, in which primary education in Australia became compulsory in 1970. So internationally, the right to education is contained, again, under the UDHR, which is a soft law, and also in the UN Convention on the Right of the Child, or it's normally referred to as CROC, C-R-O-C, of 1989, stating that education in primary schools should be compulsory for all children. Again, soft law. So it was actually enacted into the International Covenant for the Economic, Social, and Political, Cultural, rights of 1967. In Australia, the right to universal education was enforced through statute law, which is legislation, under the Education Act of 1990, where primary education is actually compulsory for everybody under the age of 17. Despite the effectiveness of this response, literacy rates amongst ATSI individuals, or Aboriginal and Torres Strait Islander individuals, remains relatively low, generally low, especially amongst remote communities. So that can highlight an area of ineffectiveness within the system, even though that we have these concepts in place such as compulsory education, we still see that there are improvements that need to be made into the system to allow a more equitable access to the, benefits of having compulsory education. Self-determination. This refers to the right of people to have and determine their own political status and to choose how they will be governed without influence of any other country. So the right to self-determination is a collective right. It is not an individual right as most of the other ones were. It is a collective right, which means it needs to be, or it is upheld by a group of people. The first concept of self-determination evolved from the UN Charter of 1945, which states that the purpose of the UN is to develop friendly relations based on equal rights and self-determination of all people. So this is held within the UN, the UDHR, and then within domestic legislation under the ICCPR and the ICESCR. All Australians have the right to self-determination of our own political affairs, so we have free and fair elections. There have been recent issues that have arisen regarding self-determination, specifically in relation to Aboriginal and Torres Strait Islander individuals deciding their own future within their country. Despite the overturning of the legal fiction of terra nullius, which is basically stating no man's land, when the British first came to Australia and determined that no one was living on this land, despite overturning this statement because clearly there were Aboriginal people on this land, they are still seeking self-determination to control the traditional land, their health, etc. Which is again something that highlights an area of ineffectiveness in the current system which needs to be addressed. Environmental rights are the rights of people and future generations to enjoy the same level of environmental quality, providing a clean and safe environment for all. There has been no universal recognition and acceptance of environmental rights. However, there have been many international treaties. We have seen some in place, such as, for example, the Kyoto Protocol, Paris Agreement. We often have summits, so the COP27, for example, summit, all of these summits that have been placed. We also had domestic legislation when I believe the Gillard government was in power, which was a carbon tax, but that was removed by the government that took over after her. So basically anybody who went above a certain amount of emissions would have to pay carbon tax. So it was monetizing something that was a social cost. This proved effective as 195 countries adopted the first universal and legally binding global deal, climate deal. Paris Agreement was a big step forward. There were lots of goals set, but I don't really reckon all of them were achieved, which is a bit of an issue because, again, you can set goals. If they're not achieved, you're not really held accountable. You have your own state sovereignty. So, yeah, it just, I guess, the only real indicator of an issue with that is that, or a real indicator of how that can become something that countries will really strive to implement is through public pressure. However, the human rights breach is seen through displacement of people, through global warming, and, you know, people becoming environmental refugees. So we see all of these natural disasters and all of these people that unfortunately lose their homes, their livelihoods, and become environmental refugees. So we see the impacts of this, and we need to do better, I guess, in terms of creating laws in place and enforcing them to improve effectiveness of the system. So this is definitely an argument that you can make. Environmental migrants aren't covered by the Geneva Convention, as it is only designed to protect those fleeing persecution from war or violence. So environmental refugees or migrants are not covered under that, which can again be an area that you can argue is ineffective in the system. Therefore, it is a necessity to add climate change, refugees into international law to protect their basic human rights. Peace rights are fundamental entitlements afforded to all people to live free from conflict, war, or any form of oppression. The right to peace is a collective right under the UN Charter. So everybody has a right to live peacefully, right? To settle disputes peacefully, to maintain international peace, to maintain security. However, in situations that may threaten regional or global peace and security, the UNSC, United Nations Security Council, is authorized to act within their powers. There's so many areas of ineffectiveness within this because they're not always able to do this because of state sovereignty. State sovereignty, you will see that I've mentioned state sovereignty maybe 100 times because really when you talk about ineffectiveness within international law, this is the first thing that comes up is state sovereignty. You can implement all of this international law, but if a country does not want to implement it, they will not. They simply don't have to. You cannot force them. If a state commences an illegal war, it is considered an act of aggression, and parties concerned can be tried by the International Criminal Court in a meaningful attempt to restore world peace, which is really, really important. But again, state sovereignty. So even if they're found guilty of acts of aggression, they can still, really the only thing that can stop them from continuing the acts of aggression is public pressure. Or, they kind of go, oh, well, this really doesn't look good. Maybe I should stop. Otherwise, regardless, they can continue on their action. So it's very, very difficult to stop a state from, what they want to do. If they want to do it, they will do it because there's really no one stopping them, even international law, because at the end of the day, they have their own sovereignty. Human rights have continually existed throughout the ages. This is evident through ancient laws, writings, inscriptions. So the UDHR is something that was adopted in response to World War I and II, where there were lots of people who passed away, there were mass atrocities, and then people realized, hey, actually, we should have something that documents our human rights. So although it does not explicitly define what human rights are and what fundamental freedoms were, it makes it, it's just sort of a document that highlights, hey, look, let's try and not have a repeat of what's happened in the past. So it is still a soft law, and again, sovereignty, state sovereignty, state sovereignty, state sovereignty, again, and again, and again, and again. That's the biggest area of ineffectiveness within the system. Okay, so despite the declaration being not being legally binding, the document carries moral weight, which is adopted by the international community. But again, if people want to do what they want to do, there's nothing that will stop them. Due to the lack of enforceability of the UDHR, it has led to the development of twin covenants in Australia, which I have been referring to time and time again throughout this lecture, the ICE-SCR and the ICCPR. They are both hard law. They are both enforceable within this country, meaning that they are legally binding and they come into force upon the ratification by a certain number of states. ICCPR is a multilateral treaty that aims to protect the civil and political rights of all individuals. This is evident through the human rights being protected in this treaty, such as the right to a fair trial, the right to freedom of thought, conscience, religion, etc. So as Australia has become signatory to this treaty, we have implemented domestic laws to punish those who breach this. So the compliance to the ICCPR is monitored by the Human Rights Committee. They will report basically on every single country and their ability to follow these laws or comply with them every 5 years. This is again just to, I guess, induce public pressure. If certain countries are not meeting the required standards, people can pressurize them, but again, they will do what they want to do if they don't want to do it, and that's state sovereignty. So again, just something I want to emphasize as a huge area of ineffectiveness in international law. They have the power to hear complaints brought by one country against another and hear complaints brought by individuals against their own government. So, Toonen v Australia, 1994, Tasmania had laws against homosexual activity. Toonen argued that this was a violation to his privacy and it was discrimination, and Australia was found to be in breach of the ICCPR. That's an example. Another example, we have Blessington and Elliott v Australia. So, imposition of life sentence on a juvenile. Human Rights Committee found rights under Article 7 had been violated. And so the federal government responded to the review and endorsed the NSW position, which rejected UN's findings. Again, another example of state sovereignty. Then we have the ICE-SCR, which is a multilateral treaty to protect economic, social, and cultural rights. So again, we are a signatory to this treaty. So for example, these would include the right to education, the equal rights of men and women, compliance with, ICE-SCR is monitored by the Committee of the Economic, Social and Cultural Rights. They don't hear individual petitions though, and Australia has been criticised by the committee as we don't have a Charter of Rights, which is like a Bill of Rights of all of the rights that exist, which you will also learn about in your studies, in legal studies. So yeah, again, Ivy Trivedi case comes in. We did go through that earlier, so I'll skip over that. So we went through the three main documents, so the UDHR, the ICCPR, and the ICE-SCR. So we have an international Bill of Rights. So that's basically our Bill of Rights, but we don't have a Charter of Rights. So that sort of concludes the human rights section of the syllabus for today for our summary in the lecture. So I'm now going to go into a bit of a summary of the lecture and just a few ending tips for you to implement. So in terms of the multiple choice, make sure that you read the questions carefully. Make sure that you read every answer. I just realized that this is incorrect, so please ignore that. But yeah, make sure you read your questions carefully. You read every answer. So reading questions carefully, make sure you're highlighting, you're underlining, especially for things like multiple choice, where some of the options may seem really similar. Just make sure that you're able to pick apart the differences. Cross out the incorrect answer or part, and underline and highlight, and make notes, basically. Make sure that if you feel like, oh, there's two options that I feel like might be the answer. Let me actually make note as to what this is. Let me make note as to what that is, and then I can differentiate between the two. Breaking down human rights questions. So first of all, look at the mark allocation. How many marks are allocated? This is a really good indication of how much you should be writing. Look at how much you need to write. You're given the lines. Those lines are there as a guideline as to how much you should be writing. Please don't go way over and please don't go under. Try and make it as similar as you can to the amount of lines given. If you go over, you're wasting time. If you go under, you're probably going to not get the full marks, okay? Look at the directive term. So what's the HSC verb at hand? And if you do a quick Google search and you go into the NESA website, you can find a glossary of all the HSC verbs. I would highly recommend reading through those, highlighting the ones that you see most often in your papers, your past papers, and being able to understand how to answer those. That's a really, really big tip that I would give everybody, is to go and just do that. It will take maybe half an hour to do, or less than half an hour, but it will help you out tremendously, as it did for me. Look what parts of the human rights syllabus it's coming from. So again, syllabus, syllabus, syllabus. We talked about the importance of this earlier, so I won't dwell too much on it, but again, just make sure that you understand how important that is. So now I've got a bunch of human rights questions. So outline how international human rights are incorporated into Australian domestic law. So how can we break this question apart? First of all, it's an outline question, so we don't need to go into heaps of detail. With 2 marks associated with questions, so the potential ways that you could get the 2 marks. You could talk about how it's incorporated into common law with precedents and courts. You could talk about legislation, or you could talk about incorporation through the enshrinement of the Constitution, which are the 3 main ways really that we can get law incorporated into our system. So have a think about how you could answer this question. I'm going to just pause here and give you a bit of time to come up with a response, and then we can continue on from there. So hopefully you've had the chance to answer that. We're now going to do the same thing for this question. So outline how trade unionism can protect labor rights. So that's the question. We first of all want to think about where your 3 marks are going to come from. Number 1, define what trade unionism is. Number 2, what about collective bargaining? All right, and number 3, can we provide legal advice to workers? Yes or no? And then what does that have to do with the question? Have a think about it. And then you can also integrate a case law example. For example, Australian Labor Party, if you're stuck and you need to find marks, that can be a good way to still get those marks. Okay, so again, have a think about how you would approach this. I'll give you a bit of time to answer that one, and then we can go from there. So hopefully, again, you've had the chance to have a look at that and figure out a sample response. But again, just try and break the questions down like this. I've also got another example for you all to have a look at in your own time. So you could definitely, so you've got access to these slides, so you could definitely do this one and then practice a couple more in your own time as well. But essentially just trying to get you guys to get in the hang of doing these types of questions and being able to break them down in this way. A few other tips. Remember that time is short. Don't waste your time. The best way to do this is by knowing your verbs, right? So again, I would recommend going onto the NESA website, going to HSC verbs, picking out the ones that you know that are really commonly assessed in your subjects and understanding how to effectively answer those and looking at the sample answers on the NESA website as well from your past papers and seeing how people have answered those in the past to get full marks. So here are some of them that I've done for legal studies, but also you can have a look for your other subjects, but these are the ones that I've seen and I know are really common. So account for, analyze, assess, compare, contrast, define, describe, discuss. So the for and against is always discuss, distinguish, to recognize what the differences are, evaluate, examine, explain, which is cause and effect, identify, which is recognize and name, and outline. So for example, here's a discuss question. So discuss whether Australia should have a Charter of Rights. So you want to be able to provide or identify issues and provide points for and or against this. So what are the advantages of a Charter of Rights and what are the disadvantages of a Charter of Rights? So writing a response that only says that we should have a Charter of Rights will only get you a maximum of half of the marks, because again, it's a discuss question, so you need to know for and against. So you need to mention that as well, right? So really, really important, and I would highly recommend that you do this, because if you didn't know, for example, that in this question you would have to mention for and against, then you could potentially only get half of the marks, right? Or you won't be able to get the total amount of marks. So being able to understand those is really, really important. So this is why I put that in there to help you recognize that. Here's another example. So explain how the Australian Human Rights Commission or another independent statutory authority promotes human rights. So explain is cause and effect. So you want to be able to talk about that in more detail in terms of how it's able to do the promotion of human rights, or how it's able to promote human rights. How can you promote? Raising public awareness, bringing forward an issue, etc. So here's an example. The Australian Human Rights Commission is a national institute that promotes human rights through awareness programs. So that's the how, or campaigns, and dealing with human rights issues. In addition, the Australian Human Rights Commission prepares and releases, again, explaining the how, reports concerning human rights. And then you give an example. So you're showing evidence of how it's done that. So bringing them home report. So compare the contributions of common law and statute law in enforcing human rights. So common law versus statute law, you want to be able to identify both sides and then be able to distinguish and compare the two, right? So common law, what sorts of things do we look at? Statute law, what sorts of things that we look at? I've got some pointers there, but I will just let you guys just have a go at answering this question in your own time using those notes, and then be able to continue that process and making sure that you are referring to the correct HSC verbs as well. So another quick tip is to make sure that you're always revising the students learn to, which is also the right hand side of the syllabus. So please make sure that you know those. That is what I'm talking about there. So making sure that you're able to answer those questions when you're going through your revision notes, as I was mentioning earlier. Okay, and that sort of concludes today's lecture. I hope that you found this helpful. I hope you learnt something new. And I hope you feel a little bit more confident leaving today's lecture. Again, if you do have any questions, we have our live Q&A throughout this lecture so that you could ask those. But other than that, thank you so much for listening in. And yeah, hopefully all of your studies go well.